And as people join, please, if you could introduce yourself in the chat. You can just share your neighborhood or ward or organization if applicable. My name is Parisa Norouzi. I'm the director of Empower DC, and Empower DC is convener of the DC Grassroots Planning Coalition. Most of the people at the meeting today will probably be folks who've been to our meetings before, but we may have a few new folks. So I'll just very briefly describe what we do. We were founded in 2017, the Grassroots Planning Coalition, to push for equitable development through planning and zoning, particularly focused initially on the DC Comprehensive Plan, which is the guiding framework for development in the city. And did a lot of work. Many of you did a lot of work over 5 years to get some key amendments in the comprehensive plan. We're now focused on watchdogging the implementation of those elements, but also looking at other ways to further equitable development and deeply affordable housing in the city. So this group is, doing work that relates to pushing for land changes in how we use land in the city, for making sure that affordable housing is truly affordable, for putting community voices first, community-led equitable development, and related work. Today's meeting, we're going to have a presentation from the attorneys from the Office of Attorney General new Land Use Division. And we're going to learn a little bit about the zoning process. Some of you may be more familiar than others. So we'll learn a little bit about the zoning process and then talk about also the role of this new division in the Office of Attorney General and some proposals that they've already put forward to make some changes. We're also going to get an update on what's happening with Greenleaf Public Housing Community and the redevelopment there. And how we can assist the leaders, the resident leaders, in their efforts to protect the rights of the residents. And then we're going to talk about the budget, which is the city is in the process with right now. A couple of proposals that we have to push in upcoming budget hearings, as well as another action that we are working on to get new leadership at the Zoning Commission. And then we'll have a little bit of time for announcements if there's any at that time. So with that, I'm going to check in with Alex and see, Alex, are you ready to start, or are you still waiting for?
Yeah, Max Tondro, the section chief, will be on shortly, but I'm ready to get going if you are. So
perfect. So I'm going to introduce Alexandra Kane from the Office of Attorney General and let her take it away.
Thank you, Parisa. Thank you guys for having us today. We're very excited to be here and to present the new mission of the land use section. And as Parisa said, just sort of give an overview of what we've been doing, as well as sort of an overview of the planning and zoning process in DC, which some of you may be more familiar with than others, but we hope that this will sort of give a big picture sort of understanding of how all the different elements come in and interact with each other. So without further ado, let me start up my screen. All right, is everybody able to see my screen? All right. So as to the new mission of the land use section, as of October of 2021, OAG is no longer in the role of counseling the Board of Zoning Adjustment and the Zoning Commission. Those responsibilities have now been moved directly into the Office of Zoning. And this has freed up our section to start doing work in advancing and advocating on behalf of the public interest in the context of land use and zoning in the district. So the way that we have sort of interpreted that or started moving forward with that new mission is sort of threefold. So first of all, there is a proactive element. So this is for us proposing text amendments, which sort of actively try to address some of these major public interest policy areas. So that's going to be things like affordable housing, racial equity, environmental justice, procedural equity, and fairness of process. So we have a couple that we have already filed, which I'll touch on a little bit later. In addition to that, we also have sort of a more reactive element, which is intervening in specific zoning commission and BZA cases. So we have started really within the last month doing that. We have intervened in one BZA case and one zoning commission case. And again, these are cases that raise sort of broader public interest issues that we think have ramifications sort of beyond the scope of that immediate case. And then finally, we're really here as sort of a resource for members of the public, community groups, ANCs to try and demystify the zoning and planning process. We work in it every day. It makes sense to us. We understand that for normal average people, it can be like trying to understand ancient Greek, a lot of it. Words do not always mean the same thing in the zoning context that they do in real life. And we understand that trying to navigate that process can be really complex for a lot of people. So trying to sort of break down those barriers to allow more people to understand it and participate more fully in the process. So in terms of our interaction with the public, which, as I said, includes groups like Empower DC, Grassroots Planning Coalition, ANCs, the sort of the public writ large, you guys are really a key component of this new mission. You're on the ground, you're working in the communities, you're going to see the problems and issues that are out there well before they sort of percolate up to either the board or the zoning commission. So we're really relying in a large part on you guys to give us feedback about what you're seeing and what issues are out there, so then we can try and figure out a way to deal with them. So we're sort of viewing this as sort of a feedback loop, where you tell us what you're seeing, we let you know what we're doing, issues that we're sort of concerned about, and then sort of providing training and feedback back and forth so that we both are able to effectively participate sort of in our own ways. So just a little bit about the intervention process. And again, this is still relatively new, so we are sort of still feeling this out as we go. But the way that it has sort of worked so far and that we sort of envisioned it working is an issue or case is presented to us, either we flag it in our review of zoning commission and board cases, or an organization or an ANC flags it for us. We do a review, see, does this really raise public interest issues? Is it really just sort of more micro issues between neighbors, or are there sort of larger policy implications of this? Once we do that review, we then determine sort of what is the best strategy for our involvement. That might mean sort of intervening directly, either with the ANC or an existing party in the case. It might mean coming in sort of as an independent third party with sort of separate, broader issues that we want to highlight for either the board or the commission's attention, or it could be taking alternative action. So instead of getting involved in that specific case, coming in saying, this is an interesting issue, but we think it has broader implications beyond just the specific set of facts in this case. We think this is better addressed through a map amendment, a text amendment, and going at it that way. So some of the, public interest triggers that we're looking for would be things like displacement of current residents, lack or insufficient affordable housing as part of a development, environmental impacts, environmental justice impacts, procedural issues. So again, lack of notice, incorrect relief, people not being able to participate fully, significant neighborhood-wide impacts, and then finally zoning appeals that come before the board, because these can sort of raise concerns or issues with the regs that we would want to look at for potentially a text amendment. And that is by no means an all-inclusive list. We realize that there are a lot of issues in the district. So, this is just sort of broad areas that we're looking at currently. So then I want to sort of highlight two recent cases, which I think sort of encapsulate, a lot of these different things that we're looking at. So Zoning Commission case 2205 is the most recent text amendment that we filed. So this was back in February. And this amendment focuses on tenant protection and preventing displacement of existing residents. So this sort of came out of a BZA case that was heard back in the fall, I believe, that involved the redevelopment of a number of apartment buildings over on Hawaii Avenue, which some of you may be aware of. Another section of OAG is dealing with sort of the TOPA issues involved in that and have brought a suit on those grounds. But we got concerned about this case because there were a large number of residents who tried to participate in the zoning commission or the BZA case and ultimately were unable to because they were not able to request party status in a timely manner, and therefore were not able to, fully and effectively participate in the case. So we looked at it, try to figure out, what can we sort of take from this to help the process going forward. And the result is this text amendment, which sort of has three main components. The first being sort of an informational requirement for applicants that are redeveloping residential properties. So this is going to require them to provide statements and information about their relocation efforts of the existing residents. Is there going to be a right to return? What is the current number and occupancy status of the building? Are they accepting housing vouchers now? Will they accept housing vouchers going forward? Just sort of basic information that we think would be helpful for the commission and the board to have when they're evaluating these cases. And this is information that both bodies have requested in specific cases, but it has not been uniform as to what they've asked for, and it's not been uniform as to what applicants have provided. So this is to try and get a level of uniformity as to the information that will be in the public record and therefore can be reviewed. In addition to that, we also wanted to try and strengthen the posting and notice requirements. One of the issues that did come up in the Hawaii Avenue case was concerns that the notice that had been provided on the property was not sufficient to adequately notify the residents as to what was going on. So made some changes there. And then finally, granting automatic party status to residents of a property. As I said, residents of a building that's undergoing zoning review typically qualify without problem under the regs for party status. But the problem is meeting all of those procedural hurdles that you have to go through to request party status. So not just filing it, but making sure that you're meeting all of the deadlines. And for tenants groups, that are trying to sort of organize themselves, that can be an additional level of complication, as it was in the Hawaii Avenue case. In addition there, you had a number of residents who did not have English as their primary language, which is sort of another hurdle. So we wanted to sort of remove those procedural hurdles for them so that these people who are going to be most affected by the relief are able to sort of participate from the get-go without having to go through all of these additional steps. So as I said, that was filed back in February. It has not yet been scheduled for a set-down meeting. We're hoping that maybe it will be for the commission's meeting late in March, which I believe is March 31st, but we'll know that as of Monday. So I will definitely let everyone know sort of what is going on with that. And then in another case, which we'll talk about in sort of in a different context later on, which I think many of you are familiar with, is the recent Office of Planning text amendment case 2207. So this had to do with making WMATA bus facilities matter of right in residential areas. So I wanted to highlight this sort of as the sort of public outreach component of our work. So when we saw that this case had been filed, it raised sort of a number of red flags for us due to the lack of information and clarity that was in the petition. So we reached out to Parisa and Empower and met with a number of other community groups and individuals who were also concerned. We're able to get a good group of people to submit a number of comments to the record, which in turn at the set-down meeting prompted both OP to try and clarify some things on the record and also for the commission to ask clarifying questions and request additional information from OP. So they did move forward with setting that down for a hearing, but the commission did ask OP to go back and provide with additional clarification as to where this amendment is going to the site that it's going to affect, which is actually a single site currently up in Upper Ward 3. And then also to provide alternative text, which would either limit the amendment solely to that site or to require a special exception process in case this needs to be applicable in other areas of the district. So in addition to our comments and concerns that we had filed, we have now also filed a draft alternate text, which is in the records. That's at Exhibit 10. They have not yet scheduled a hearing on this, so it's still sort of in limbo as to when this is going to be heard. But we would suggest that the members that are here on the meeting today take a look at the text that we filed. We would hope that some of what's in there is agreeable, but if not, by all means, please go ahead and file either comments on it or suggested text that you might have. We really just sort of wanted to prompt that conversation and sort of give people ideas as to what else could be done to address this issue. So having gone on with that, now on to sort of the planning and zoning overview. And like I said, I hope this isn't too repetitive for people. I will try and move through it relatively quickly, but if I'm going too fast, please let me know. So first of all, the difference between planning and zoning. These are two terms that are sort of used interchangeably a lot of the time, but they do represent two different concepts. So planning is aspirational. Planning is the comprehensive plan, which takes a long-term view of what sort of goals and patterns for development the district has going forward, in a 20-year period. So the comprehensive plan in DC is drafted by the Office of Planning on behalf of the mayor, subsequently adopted by council. The zoning commission does not have any role in the drafting process. So I just want to make that clear that for the drafting, sort of coming up with these long-term goals, that is not the zoning commission. Once it has been adopted, it then becomes sort of the bedrock for the zoning map and the zoning regulations, which are built off of it. And in that process, the zoning commission does have a large role. They set the zoning regulations based on proposals by OP and the public, and can then amend them and the zoning map subsequently. So right now, we just finished an amendment process with the comp plan, as many of you worked on actively. We're looking to probably start the, rewrite in 2025. So that's sort of an upcoming thing to have on everyone's radar. And so, as I said, the zoning regulations build out of the comp plan. They take sort of these larger aspirational goals and make them into the concrete built reality that we see every day by imposing specific standards and requirements on developments in the district. So these are going to be your height and bulk requirements, requirements of things like parking and landscaping to a degree, and then also what are the permitted and not permitted uses in the individual zones. So in considering the comp plan, you have to remember that it is sort of comprised of three main parts. There are the two maps, the GPM, the generalized policy map, and the FLUM, the future land use map. In addition to them, you also have the written elements, which are the citywide and the area elements. And when they're reviewing their cases, the zoning commission has to consider all of these. It's not just the maps, it's not just the elements, they have to sort of take the comp plan as a whole. And another thing to bear in mind is that the comp plan is not directly relevant if a project is a matter of right. If a project is a matter of right, it's in compliance with the zoning regulations. And since the zoning regulations build off of the comp plan, it is therefore assumed to be in compliance with the comp plan itself. So this really only comes up in discretionary reviews before the zoning commission. So in terms of the text, again, sort of three main components of it. There's the framework element, which is the introduction, the interpretation, how you sort of use all the different elements of the comp plan. The citywide elements, which cover policy areas that apply across the district. So these are going to be your main areas like housing, transportation, economic development, infrastructure, things that are going to apply, again, across the city. And then you have the geographically centered area elements. So these are going to focus on the particular planning goals of different geographic areas of the city and are going to take into account, what is the character of that area? What are the specific needs in terms of planning and development going forward? Does it need more housing? Are there historic preservation elements that have to be taken into consideration? Just sort of a more fine-tuned understanding of what development needs to do in that area of the city. So in terms of the maps, the GPM designates areas sort of broadly as to whether they should be conserved, enhanced, or changed over the entire span of the comp plan. And then the future land use map, designates what are the anticipated future land uses of the area, which may stay the same, they may change depending on areas represent sort of mixed use areas with different residential or commercial uses mixed in. And then the other sort of component of the comp plan, which is part of the comp plan, but not entirely, are small area plans, which go sort of beyond the area elements and provide an even more sort of detailed and site-specific planning goal for a specific smaller geographic area. So SAPs guide the commission. They're not fully binding on the comp plan unless they've been adopted as an amendment to it. But they do provide sort of an extra layer of guidance for the commission when they're evaluating things to determine, is this in line with what this specific community wants? They do also help sort of direct development in that area by providing additional guidance to developers. And then for the ANC and the other entities in the district that are evaluating the project down the line to see if the project is consistent with the goals of that area. And just for the terms of the ANC and sort of community groups that are involved with this can also be important in terms of for PUDs, determining public benefits and that sort of thing, because these are all sort of clues that the SCP can provide as to what that specific neighborhood is looking for. Okay, so a brief who's who of who does what in zoning in DC. So first of all, the Zoning Commission. As I said, they are in charge of the regulations effectively. So setting the initial zoning map and zoning regulations, then handling amendments to them. And then reviewing applications for large scale projects that have sort of broader policy implications for development in the district. So planning unit developments, design reviews, campus plans, projects that usually incorporate a larger geographic area and have larger impacts on the surrounding community. Below them, we have the BZA, which is how the majority of the public is going to interact with zoning. So special exceptions, variances, appeals to the zoning administrator, and then occasionally embassy cases. Sort of in support of them or working with them, you have the Office of Planning, which is split into two main components. You have the comprehensive planning portion, which handles the development of the comp plan, development of small area plans, focused again on what those long-term development goals for the district are. And then you also have development review. So these are the folks who draft amendments to the zoning map and the zoning regulations, and who also review the individual cases that are coming before the commission and the board for consistency with the zoning regulations and the comp plan. In addition to them, you have the ANCs who are going to review the applications and whose issues and concerns are afforded great weight. And just one thing to call out for the ANC, what's given great weight are issues and concerns. Of course, with the Office of Planning, it is the final recommendation as to whether it should be approved or not approved. ANCs are also able to file amendments to the zoning regulations and the zoning maps. So they're able to participate actively, not just reviewing cases. And then finally, the Office of Zoning, which is, as of October, is now charged with providing administrative and confidential legal support to the Zoning Commission and the board. And then off in our own little corner, we have OAG, who as it now is completely independent and is able to come in and advocate for public interest issues as we see them come up in these different cases. And then just very quickly, a couple others agencies to keep in mind. You do have the zoning administrator at DCRA, who is going to be reviewing all applications for building permits and certificates of occupancy for compliance with the zoning regulations. Decisions of the ZA can be appealed to the board. Ddot is going to be weighing in on most applications for contested cases, as well as map amendments for what are the traffic impacts of this project going to be. Unlike OP or ANCs, their recommendations are not accorded great weight formally, but they are, as the district's planning transportation expert, accorded a level of not great weight, respect, we'll say, they are giving credence in determining these decisions. And then finally, historic preservation, just wanted to touch on briefly because that comes up a lot in terms of trying to understand the different people involved. Historic preservation is sort of a related but separate track from zoning. So historic preservation is going to be establishing those historic districts and then evaluating a project's design against those standards. It's sort of a separate, like I said, review from zoning, focused really solely on the design elements as opposed to the bulk and height standards that zoning is concerned with. So a quick overview of zoning commission cases. Firstly, you have your applications or contested cases. So these are going to be things like your planned unit developments, design reviews, campus plans. Because they're contested cases, they allow for participation by parties. So the ANCs and any other parties that want to request party status, either in support or opposition. They're evaluated on the basis of specific criteria. So PUDs have their sets of criteria, design reviews do, campus plans do, and in addition to that, they also have to be found not inconsistent with the comprehensive plan. Then sort of in the middle, you have map amendments, which can take the form of either contested cases or rulemakings, depending on the scale of the map amendment and who's bringing it. And so this is a change to the zone designation on the zoning map. So in going through that, the commission has to make a determination that the proposed change to the zone is not inconsistent with the comp plan. And in looking at that, they're going to be looking primarily at the GPM and the FLUM. So what are they anticipating in terms of development in this area, and does this map amendment line up with that? And another thing to bear in mind with map amendments is that they are not tied to a specific project unless they're filed in conjunction with a PUD, in which case they only govern the PUD site, and should the PUD expire, the map amendment expires and it reverts back to the prior zoning. Then finally, zoning text amendments. So these are amendments to the text of the zoning regulations. They can be brought by anyone. Sort of historically, OP has brought the bulk of them, but they can really be brought by any member of the public who thinks that there should be a change to the regulations. You need to demonstrate that the proposed text is not inconsistent with the comp plan. And that's going to be what the commission evaluates it against. So just two other things I wanted to touch on in talking about zoning commission cases. PUD public benefits. So this is sort of a special feature of PUDs that in addition to meeting the specific criteria in the regulations, they are also required to provide benefits to the surrounding community. So these are going to be negotiated between the applicant and the community / the ANC as part of the application process and are subsequently memorialized as conditions of the final order and enforced by the zoning administrator. And these go sort of beyond, standard conditions that we would see in a BZA order, in that they're not solely mitigations of the relief involved. They sort of go farther. There has to be an active sort of benefit that is provided to the surrounding community. And finally, racial equity, which I'm sure this group is very familiar with at this point, since it came out of the latest cycle of comp plan amendments, is that the zoning commission is now required to review applications through a racial equity lens, and also to develop sort of specific tools and processes for evaluating racial equity as part of the applications. So in terms of BZA cases, typically they're going to fall into two main categories: special exceptions and variances. So special exceptions are uses and development standards that have sort of been predetermined to be consistent with the comp plan. They're sort of anticipated by the regulations and by zoning. So to get a special exception, what the applicant has to demonstrate is that they're not going to have an adverse impact on the surrounding properties that cannot be properly mitigated, and that they also meet certain additional criteria. So that might be screening, it might be other mitigations that are sort of pre-built into the regs. Then you have variances, and variances are not, as is sometimes presented, sort of a stronger special exception. Variances are their own thing. Variances are not anticipated by the regulations. They are a complete deviation from the rules. They are not anticipated, and as such, an applicant for a variance has to demonstrate that there is some unique condition that renders compliance with the regs impossible, and that trying to comply with them would result in either a practical difficulty if it's an area variance, or an undue hardship if it's a use variance. And then the final two factors you have to demonstrate will not harm the purpose or intent of the zoning regulations, and then it will not result in any undue adverse impacts on the neighboring properties. So again, much higher bar, much different sort of focus than a special exception. Then finally, appeals to the zoning administrator. So these are things like issuance of a building permit, issuance of a certificate of occupancy, which the appellant alleges are in violation of the zoning regulations. Okay, so a couple quick issues to touch on in terms of BZA cases. First of all, BZA cases can be self-certified, which means that instead of getting a letter from the zoning administrator indicating that an applicant needs relief, the applicant's attorney or architect signs off on the relief that is needed. And therefore the applicant sort of assumes the risk that all of the correct relief has been identified and it has been identified correctly. Sort of part and parcel to that, the thing to bear in mind is, what is the real role of the BZA? The BZA has the final responsibility to interpret the zoning regulations. It's not the zoning administrator, it is the province of the board to review the regs and make an interpretation as to their meaning. And then finally, summary versus full orders. This is an issue that comes up more in board cases than with the commission. Summary orders are just that. They're a quick summary of what happened in the case that do not include full findings of fact or conclusions of law, and therefore not binding precedent on the board. A full order does include all of that information and therefore do constitute binding precedent. So a full order is required if the board's decision is adverse to a party, be that the applicant in the form of the denial, the ANC, or any other party. Okay, so moving on to topics that we thought might be of particular interest to this group. So public participation. I said this is something that we're really focused on in our new role, is trying to encourage more of this in the zoning process. So the way this is going to take form is sort of two different ways, both written testimony and oral testimony. So in terms of written testimony, and you'll see at the side I pulled out two of the filings from 2207, which I think highlight sort of different key issues. Some things to sort of consider when filing written testimony are, first of all, the timing. And there's sort of a strategic element as to when you want to file things. First of all, for zoning commission cases, PUDs, map amendments, text amendments, sort of the initial bite of the apple comes at set down. So this is what happened in 2207. We identified issues with what was being initially proposed, and we're able to sort of set the trajectory for the case going forward because a number of different groups filed comments at set down, asking for more information, asking for clarification, which is now going to be incorporated going forward. So that's sort of your first key date when looking at zoning commission cases. All other cases, if they don't have set down, typically you're going to want to look around the 14 to 10 days before the hearing, because that will put you in before the Office of Planning files the report. So that means that there's still time for the Office of Planning to take the comments of the public into consideration. And then sort of the drop dead date, as we see it, would be the Friday before the hearing, because that's when reports go out to the commission. That's sort of when the commission and the board are going to be reviewing things in detail that weekend prior to the hearings. So making sure that you have your submissions in the record before them sort of ensures the best possibility that they will be read in their entirety and sort of understood in the context of the full record. The real drop dead date is, of course, 24 hours before the hearing, which per the regulations is sort of the cutoff point. Anything that comes in after that, you'll have to request to be entered via oral testimony at the hearing. And that can be particularly problematic if it's a meeting case where you would not have the opportunity to do that. And then in terms of what makes effective written testimony, there's a couple of things that we've seen which we think are helpful. First of all, sort of focusing on how is the application meeting or not meeting the standards for the requested relief. So what do the regulations require? Has the applicant met them? In a convincing way? Have they addressed everything? Have they not? Really sort of keeping it focused on the regulations themselves. What sort of information is missing that the board or the commission is going to need to understand this fully? So this was a key issue in 2207. As I said, the Office of Planning's initial petition did not include a lot of that key information as to where this would be located, what criteria they're going to be looking at. So you can see in the filing from Empower DC and Grassroots Planning Coalition, that was sort of the focus. Like, this is the information that the commission needs to evaluate this. And I think that was critical for the commission themselves to sort of wrap their head around, oh, this is stuff that's still outstanding. This is stuff, yeah, it would be helpful to see that. In addition, sometimes, this is not going to happen in every case, if you see sort of possible alternatives, either in terms of additional relief that could be needed for text amendments, is there a better way to do this? Presenting those alternatives as well can sort of help the board and the commission start to work through either additional information they need or trying to figure out, is there a better way that this project or goal can be achieved? So looking at the filing from 5D in 2207, that was what they did. They had suggestions for how the language of the text could be changed in a way that would make the regulation clearer and address some of the concerns that people had. So that is another thing to consider. Like I said, it's not always going to be applicable, but if you see an alternative route, by all means, we think it's important to put that out there. And then finally, in terms of requesting conditions, and I think this comes up sort of more in the ANC context, so I just want to put it out there, to make sure that whatever you're requesting in terms of a condition relates back to the relief being requested. So that we see this happen a lot in BZA cases where people sort of throw everything up against the wall in terms of proposed conditions, but the board is going to be limited to only implying those in the final order that actually mitigate the relief being requested. So there has to be that direct connection. And then in terms of oral testimony, a lot of this is going to be similar to what goes into the written testimony, because I think for most people, that's what they're going to be relying on when they show up to testify. So really getting stuff into the record and in writing from our standpoint is probably the more critical thing to testifying orally, because then it's clearly documented in the record. It will have to be addressed in any subsequent order. So the written testimony is really key. And the oral testimony really should build off of that and just sort of highlight your key points. So things to bear in mind, individuals will have 3 minutes to testify, whereas organizations will have 5 minutes. And then parties have the same time collectively as the applicant and any parties in support, which in theory is limited to a max of 60 minutes, but in practice, usually the board and the commission tend to be flexible with allowing, larger amounts of time, specifically if it's a, highly contested case. Again, like written testimony, really trying to sort of keep oral testimony focused on how the application is or isn't meeting the criteria of the regs, and then sort of highlighting any additional information that you think is needed to understand the case or clarify any open issues. And then one thing to sort of avoid is getting into personal attacks on the applicant or other members of the public. We understand that, like in heated cases, that can be very difficult, but that does tend to be something that will sort of divert the focus from the case at hand, which is really important to get the actual issues addressed. And then finally, for both the written and oral testimony, as we saw in 2207, trying to get large groups of people forming coalitions to testify orally or submit written testimony, we think is key, because it demonstrates that this does have larger impacts than just the specific case or the specific issue. This is going to affect a broad group of people, and it also provides a range of different angles for the commission and the board to consider. And we think, especially for something like a text amendment or a map amendment, we really want to get as many people participating as possible, because these are the maps and the regulations that are going to govern development in the district. So really, everyone should be weighing in actively on those. And then finally, just sort of want to touch briefly on sort of a current issue that we've been seeing a lot, and these are map amendments and the IZ Plus program. So we already sort of touched on what map amendments are. The IZ program, or the IZ Plus program, is sort of another layer on top of that, which seeks to capture some of the additional density from an upflumming and a resulting upzoning by requiring additional inclusionary zoning in certain circumstances. So this has come up in a couple of recent map amendments. And then wanted to sort of highlight that as part of this, OP does have the option to recommend either that an alternative zone may be more appropriate, and then also that they may recommend against the imposition of IZ Plus due to other mitigating circumstances. And you can see that they've done that in 2 recent cases, both in Ward 8, 2117 and 2119. And so that brings me to the end. I know that was a lot of information all at once. I hope it was helpful. I will drop Max and my contact information into the chat as well. But at that point, I will close out of this and turn it over to questions.
Thank you so much, Alex. And I just want to say to the group, by no means do we expect everybody to have absorbed all of that information. But what I hope it does is give us a snapshot so that we can start to figure out what we want to learn more about. And I think the real game changer here is that now we have Alex and Max to help us understand these issues, whereas before we never had anybody within the city government, any of these agencies, that was really committed to assisting the community with navigating the zoning process, right? And you see how complicated this is. Alex and Max both have years of experience working directly with the zoning commission and interpreting these processes and these laws. So I think the key thing we want to be able to do now is make sure all of you are aware of them, that if issues are coming up in your community, that you should tap into this support. And yeah, we're gonna do some question and answer and talk a little bit more. Max, you want to go ahead and introduce yourself real quick, and as we do Q&A, you can chime in with those too.
Yes, hello everybody. I apologize for being a little bit late. My name is Max Tondro. I'm with Alex. We're the land use section of the Office of the Attorney General. As I think Alex already introduced us in our mission. I come from a background of having been with OAG, the land use section now for since 2018. Before then, I worked briefly with Maryland National Parks and Planning Commission in Prince George's County, and before that with DCRA at representing the zoning administrator. So, and before that, I served in a variety of different government agencies as a Capital City Fellow. So that's my background.
I'm going to pull some questions from the chat, and while so feel free to add more to those. If anybody can't put it in the chat for any reason, you can try to raise your hand on using the hand function. One question I wanted to start with, one of the issues that we've dealt with is, through the planned unit developments, there's public benefits agreed upon. Sometimes it's a community benefits agreement, and there's very little enforcement of that. And I heard in your presentation, Alex, you said that the zoning administrator is responsible for enforcing PUD benefits, public benefits from PUDs. I had never heard that before. I was wondering if you could describe a little more, what does that enforcement typically look like?
I think I might turn this over to Max, since he has a little bit more, since you've seen this from the DCRA side as well. He'll probably give a more complete answer than I will.
Yeah, so just to be clear, right, what the zoning commission, the zoning order, and what the zoning administrator enforces would be the zoning order. So if there are conditions that are specifically included as part of the zoning order, then that is what they will, that's what the zoning administrator is charged with enforcing. The difficulty comes up if there is a separate side agreement between the community or with the ANC and the developer, where you have a community benefits agreement that is not, because it's not really directly relevant to the authority, the jurisdiction of the zoning commission, then that's something that is not enforced by the zoning administrator. So that's sort of one potential issue. The other potential sort of source of confusion or ambiguity may come about depending upon how the conditions are written. There are times when conditions, even in the zoning commission order, are that the applicant shall make best efforts to work with the community on X or Y. Those are obviously subject to different interpretations depending on which side one's on, and that can be another source of conflict. I think the way to address that is to make sure that at the time that the conditions are adopted by the zoning commission in the order, that they're as clear as possible in terms of what is required. But if there is let's just say, oftentimes there's a community room that's available for use by the ANC as a standard requirement, then that would be something that would have to be shown prior to the building permit, prior to the certificate of occupancy. There will be then that would be shown on the plans as part of the permit. And then if the requirement in the zoning commission order is that is to be maintained in perpetuity for the life of the project, then if for some reason the owner sells to another owner, the other owner forgets about it or says they forget about it, then the enforcement would be to go to the zoning administrator, say, zoning administrator, this is a requirement, and the developer or the current owner is not abiding by that rule. And the zoning administrator would then do an investigation to determine whether or not the zoning administrator agrees, and then take the appropriate action. If for some reason there was, the person who made the complaint who felt that the order was not being upheld, if the zoning administrator disagreed and said no, the owner is doing what they're supposed to do, then at that point it is possible for the complainant to say, well, look, I think the zoning administrator is wrong, and then to appeal that to the Board of Zoning Adjustment if they so choose.
It sounds like that area of making sure that the orders are very specific is something that we might want to follow up on and understand more. There's a question from Paul Johnson. Can you talk a little more about, you mentioned that ANCs can submit zoning amendments. Is that only the full commission as a whole, or can individual ANC commissioners?
So if the ANC wanted to submit it on behalf of the ANC, then yes, that would probably have to come out of a full ANC resolution doing that. If an ANC commissioner sort of in their personal capacity, just as a member of the public, wanted to submit one, they could, but it would not be on behalf of the entire ANC.
Could it be on behalf of their single member district, or is that not a thing?
I don't think that, and Max, correct me, I don't think they could do it on behalf of their single member district without input from the full ANC. I think if they wanted to do something sort of as a one-off, it would be them in their personal capacity.
I think that's generally the case, and I'm sure that the commission would be I mean, I think, for example, I believe in one map amendment that was proposed by the ANC, it was the lead was taken by the single member district commissioner, but she not only got the community to agree with her and to support the proposed change, but also got the rest of the commission. And I'm sure that that's sort of an important thing that the commission is going to be looking for to make sure that this is not a one-off, or that there's understandable why, let's say, the rest of the ANC does not believe that the map is not in support of the map amendment.
Ann Hoffman is asking about whether the zoning commission is doing anything to develop the racial equity process that's required in the comp plan, and can they be sued by the Attorney General or somebody else if they're not doing it?
So I think the commission has stated several times that they believe that they are taking the steps necessary to adopt it, and they have given that responsibility. They've tasked the Office of Planning, which again is their technical advisor, to deal with the racial equity analysis, to come up with a tool and a process for doing that. Office of Planning has said at the most recent oversight that they were in the process of working through that and coming up with that. Obviously, that that's what both the Office of Planning and what the Commission have said. I don't believe that the Office of Attorney General has a position. The charge to impose the racial equity analysis comes from the comprehensive plan. There are, I think, at some point questions as to whether or not the council can actually make the commission do something. I think in this case, it's clear that the commission wants to do something. And I think the concern is whether it's from the community, is whether or not it is fast enough and whether it is done appropriately, that or meaningfully. This is, again, the racial equity analysis is an ongoing process where other jurisdictions are experimenting, trying to figure out exactly how to work through it. So I don't think that there would be. I don't think that it'd be possible that I can't see the Attorney General suing on that one. I don't think that there'd be legal grounds above all. But I think the real issue is, again, that the commission has indicated that they want to do this. They've taken that task on. They are very clear about that. And the question, I think, for the community is to make sure that they play a role, to the extent they want to shape whatever that racial equity analysis, that tool, that lens, how is it going to be used, what is appropriate. Presumably that will be something that would come before the zoning commission as a text amendment to create a clear process in the zoning regulations. It is not clear if that's what the Office of Planning is thinking or is considering doing, but that again is an option or an opportunity for community folks to participate and to make that clear as to how they want to or not want to do that.
Question from Ann Hoffman. Do you think the Attorney General can get involved in making the housing authority behave better beyond public safety and lead issues?
So I think I'm gonna have to make a pass on that. That's sort of out of my jurisdiction. I know that the Office of Attorney General is concerned, has been very concerned but that's another part of OAG that I'm not privy to exactly what they're doing, other than that it is something that they're very much concerned about.
It sounds like we should follow up with the housing section over there. Let's see. Tori is asking if you can give an example of when a community benefits agreement was enforced. I think maybe she's saying the way you described. So I think it must be the not the community benefit agreement, but the agreements within the PUD. Are there any
Sure.
examples?
Right. So, the one that springs to mind that's the most common will be transportation related. So, for example, you'll often have a situation where, because PUDs are generally pretty large, so there's going to be a fairly substantial and direct traffic impact. So, for example, there may be the nearest signal will have to be redone. There may be on-street parking issues. There will be a requirement that they redo the sidewalk around the site. There may be a requirement to widen an alley. All of those are classic conditions that are enforced. Another one would be issues of, like, there would be an ongoing, would be trash and loading. For example, establishing that there's loading can only happen between 8:30 in the morning and 4 in the afternoon, that it can only happen in this one area. Trash pickup can, in the same kind of limitations, depending on the particular use. Obviously, restaurant use is very different than an apartment use. So those are the kind of conditions that can be imposed. You'll also have PUDs have that requirement that there be public benefits. And so when there are public benefits that are incorporated, those are required as conditions. And so, for example, there might be, as I said, oftentimes there's a community room that's available for either the ANC or the larger community that can be booked. There may be, I remember one time there was a requirement that the certain street signs, historic street signs and tree planters were installed, again, as part of a public benefit. Another classic example is a money that was transferred to a PTA, local PTA school, that for a specific purpose, it had to be specifically identified, and the money transferred prior to the certificate of occupancy. They're very clear and tight restrictions on how money can be, transfer of money can be incorporated as a condition as a public benefit. And then there are various different other examples. Obviously, one of them would be just the building of the design of the building itself that has to correspond to the plans, or they would have to modify, go back to the commission for the plans. So there are a whole panoply of different kinds of conditions that are enforceable. Generally, the zoning, what I would say would be that those will be either sort of in two buckets, either things that are able to be ascertained, their tasks have to be completed prior to the certificate of occupancy, that would be building related, or their ongoing requirements like operation issues, which would be like the trash and the loading that I mentioned earlier.
I'm gonna go through the ones in the chat before I call on hands, but is that Matt LeGrant, who is the zoning administrator that's in charge of all that? Okay, so
Yeah.
it's interesting because I did have a conversation with him once, and he was like, basically my role is to check on the parking, make sure that there's enough parking, so I was like, oh, okay, so that doesn't sound like full explanation of what all right, our Zachary's question, are community benefit agreements typically in the zoning orders, or is that uncommon?
No, so again, you have different kinds of orders. So if you have a zoning commission order for a PUD, because a PUD or a PUD is providing more flexibility, there are these requirements for public benefits to balance that out. Therefore, as a result, there are going to be some more conditions, and those may be, again, benefits that are given to the community to make up for the extra flexibility. That is more likely to include things like that you would find in a community benefits agreement. Where you have instead, let's say, a design review or a map amendment, you're not going to have those same kind of orders, same kind of conditions in the orders, just like with the Board of Zoning Adjustment order. Those will have to be, generally those conditions will be related directly to the specific relief that's requested. There has to be a connection between them. You can't say, you're building a big building, I want you to redo the traffic signal 18 blocks away, because there's no connection between the two of them.
Can the Attorney General land use section get involved in issues relating to rent control and vouchers that do not go before the zoning commission or BZA?
I think that would fall probably under Jen Berger's section. The housing justice section is the one that would be able to handle and deal with those issues.
Let's see. Nick's question, what is the difference between the racial equity lens you are developing and the statements we hear from Ddot director that he has thoroughly applied racial equity to its programs?
So I think the whole racial equity analysis that was introduced in the comprehensive plan is intended to apply not just to the commission, but also to all. And I think it's not just coming from the council, but also presumably from the mayor as well, and the administration, the idea of trying to incorporate in all decisions going through the district government, that there be a racial equity analysis be included. So therefore, as a result, you have both the council office on racial equity, you have the mayor's office on racial equity. You know, these are, and then there, as part of that, there is throughout the administration, each of the agencies are supposed to be working through coming up with a process to incorporate a racial equity analysis in their daily decisions, as well as including the budget decisions. So the difference would be just simply that when Ddot is doing whatever activities they're doing, they have to take and they will be doing their own racial equity analysis. When the zoning commission does theirs, they do their racial equity analysis. When the Office of Planning does whatever activities they're doing a racial equity analysis. When the council takes action, they do their racial equity analysis. So though there may be, for any given piece of legislation or action, there may be multiple, if there are multiple agencies touching it, there in theory should be multiple racial equity analyses done by each agency for their part thereof.
Paul's question, can specific equitable hiring practices be an enforceable public benefit condition of a PUD?
So it's quite common that there be first source requirements. Those are common. I think the devil will be in the details as to what can or cannot be required and what an applicant may be willing to do. So it really depends. So certainly the first source is something where you're giving an opportunity for district residents to have a first chance. You know, the other classic example would be that there be job fairs in order to try to attract local residents and so forth.
Okay, so I think we're just going to take a couple more because we're coming up on 2 o'clock. So I have 2 more in the chat, and then I have Chris Williams' hand up. So I have Zachary, when anti-displacement measures like housing first or right of return are changed or disregarded, what remedies are there within zoning?
So the zoning commission will be considering, they're charged to, you know, obviously they have a basic charge, which is to maintain and to foster the public health, welfare, and safety. And that's sort of the overall charge that they have. They're, in doing so, they're also charged to not be inconsistent with the comprehensive plan, to be following that guidance that comes from the council and other public policies. So to the extent that there is an issue with housing, you know, housing first, or some of these other policies that are adopted, clearly the commission considers it, but is it a fundamental, you know, the zoning commission is not charged to enforce that, or their job is within the arena of zoning to deal with it. So it's an issue that they will consider, but it is not necessarily, and again, it will depend upon the specific details of what it is that's being addressed. So for example, like a housing first, you know, if you're dealing with multiple sites, site A, there's a project in site, you know, and that's going to be redeveloped, and it's going to involve moving folks from B to C, or there's a multiple phase or that kind of issue. The zoning commission will only consider, and only really within its purview, is that the specific site that they are, for which they're reviewing the zoning. And so it is linked, there are relationships, and that's why it really depends on the specifics of what is before the commission at the time, because that's really what they are reviewing and considering.
I think that's an issue that, you know, we probably need to follow up on as well. Just it relates somewhat to the text amendment that you all have submitted that asks for more information about whether there's a right to return, you know, what the relocation plan is. And we dealt with this also in Berry Farm, just trying to get it in the zoning order that there was a right to return because the housing authority was saying they have a right to return, but they, you know, it wasn't reflected in any enforceable document. So anyway, but that could be a whole conversation unto itself. Last question from the chat from Gail is the processes and offices and agencies that you've spoken about. Do they work effectively and provide the needed checks and balances? If not, what improvements would you recommend if there was a way to make systemic changes to this whole milieu you've described? Big question.
I'm about to say this. It's a good last question.
Yeah.
I'm sure, you know, you talk to 5 people and you'll get 10 answers, all of which will be different with some overlapping, because there's multiple ways of addressing issues, different ways of dealing with that, dividing up responsibilities. I mean, I think it's probably such a broad question. I don't know. I mean, I think we also have to, we're also working with the institutions that we have right now. And I think it at some point is much more efficient probably to be working on how to improve those rather than trying to completely overhaul them or switch them around. I remember when I was at DCRA was the process, that was when the process of splitting the agency was started. And that's been dragging on, even though I think all members of council were assigned onto it from the very get-go. That is something I want to say it's going to be at least 5, 6, 7 years before that split takes effect. That was a relatively easy split in the sense that it was taking a big agency and dividing it into 2. And so, you know, in other words, keeping everything that's already there, just breaking it into 2 different halves and respecting the internal separation. So I'm always a little bit wary of, you know, trying to completely change things overnight. You know, is going to take a lot of energy and it may not result in the changes that one wants. I think sometimes it's more effective to use the processes that we have that are already in existence and work through them to try to improve them. It may not be, again, everyone has a different response. You will have a different way or 5 different ways in which they could reimagine things. But I think there are ways to work through this. I mean, Alex and I would like to think, I think the Attorney General would like to think that our new mission will be helpful in trying to hopefully to demystify and enable more participation by more folks in the zoning process. And that itself may have a large effect. It may just take time. It takes energy. It takes time.
Yeah, and we're gonna discuss a little more later in the meeting some other thoughts about, you know, new leadership at the Zoning Commission and different aspects of Office of Planning, et cetera, that kind of relate to that. So last question from Chris Williams.
Thank you all for attending today's webinar. I'm trying to really understand the big picture here. And as you all have talked about, there's sort of a hierarchy, for lack of a better term, for how we really should understand the effective pathways that we have for affordable housing production, which is really, of course, what our group is interested in. And how much of the future land use map, of course, this is being contested in court, as you know, is a matter of right, meaning how much of the total development for, say, the next 10 years are we saying falls under the comp plan versus matter of right? And is that 95%? So we're really only talking about 5% where we could have through community engagement efforts and work with the Zoning Commission, greater affordable housing, meaningful, I should say, affordable housing production. Can you give us some insight into the comp plan, the comp plan's relevance vis-a-vis the new future land use map and matter of right?
Yeah, no, that's a great question, Chris. Thank you. So I think the answer would be that there is a process, the FLUM, the future land use map, which envisions and identifies the appropriate density for various for properties all throughout the district, right? As part of the comprehensive plan update, the FLUM there were numerous changes that were made to the FLUM. Generally, those were what we would call up flumming. They were increasing the allowable density that was allowed on various different parcels. And the expectation is that there will then subsequently in the coming years, there will be a series of map amendments that will come before the commission, which will try to change to reflect those changes in the FLUM designation, the increased density anticipated for a particular property, and try to incorporate them in the zoning map to update the zoning so that the zoning would then corresponding, let's say there's an increase from a low density residential to a moderate density residential, there would be a change then proposed subsequently before the commission to change the zoning, let's say from an R2 to an RF1, from a residential house zone to a residential flat zone. So what that means is the FLUM has changed, but there will be a series of changes going forward before the commission to determine whether or not a particular parcel should be as it were upzoned to allow the increased density. I think what that means is when the commission makes those decisions, let's just assume that the commission says, since the FLUM has changed, we agree with that. We are going to change the zoning and upgrade the zoning. The zoning of the parcel then now has increased density. And I think as Chris is alluding to, those will be the owners of the property will therefore have more that they are able to build by right. In other words, they do not have to go to the board or to the commission to ask for relief in order to be able to build more. So obviously that means there are going to be a lot more matter of right projects. There is still the possibility, of course, that an owner may say, well, that's good, but that's not enough. I may still need to go back to the commission or to the board to get relief, depending on what they want. But it certainly does mean that there's going to be a lot more development that will occur as a result of the FLUM changes that will lead to more matter of right construction. Once, and however, that's the important thing, once or if and when the commission approves a map amendment. So that I think is a time for, if one is concerned, that is a time about participating in the zoning commission's consideration of a map amendment as to what is the relevant zone and the reasons for why they should choose zone A or zone B. Because one thing I would hasten to add is that the future land use map is one part of the comprehensive plan, but there are other parts of the comprehensive plan, and the commission is charged with reviewing all of them as they're all parts of the comprehensive plan interpreted, integrated together. And the future land use map does not identify one category as applicable to only one zone. There is a range of zones. There are a range of different kinds of density or uses that are anticipated in the site on the particular property. And that again, because the future land use map is a planning document, is aspirational, looking to the future, whereas the zoning is looking to codify and establish specific rules and regulations for right now. The matter of right, I saw there's a question in the chat. Matter of right means that as long as a property owner complies with all the regulations in effect in the zoning regulations for that property, for that zone, they can just go and get a building permit. There is no community involvement. There is no approval process, review process by the Board of Zoning Adjustment or by the Zoning Commission. So for example, if you want to go build, you're in a zone where there's a 40-foot maximum height. If you don't want to go above 40 feet, you're good to go. You have to comply with other restrictions, your front yard, your rear yard, you have certain uses you're going to be limited to. But as long as you work within those, then you can go straight to DCRA and get a building permit. They'll be reviewed for zoning compliance by the zoning administrator, and then also for construction code compliance. And assuming they pass all that, then they would go through and they would get their permit. There would, in other words, I think what Chris is getting at is there would be no opportunity for community involvement or engagement as to the development of a particular site.
So I guess
That instead, yeah.
So I guess what I'm asking is, of course, your office is trying to do sort of two things at once that are not necessarily compatible, which is defend the government's passage of the FLUM map, right, in the lawsuit with myself and others. But then you're also asking for greater racial equity. Those two things, of course, are not compatible. And so what I'm really trying to understand is what are the implications of the new FLUM map. So there are few barriers that would sort of prevent the zoning commission from not adapting a map amendment that is consistent with the FLUM. I can't, in fact, think of anything that would prevent the zoning commission from doing that because it is baked into the law, right? And so what I'm really trying to get at is how can we envision a more inclusive city that provides for affordable housing and family housing if we have this thing called the FLUM map that basically has facilitated matter of right construction. Do you get what I'm asking?
Yes, I think so. And obviously, to be clear, I can't comment on that lawsuit. But I hear you, Chris, and in terms of that, I think. So I think I first say that the zoning commission, I think, has at times there have been rezonings where proposed map amendments where they have chosen to go with a different zone than what was originally proposed. Again, because there are multiple zones that can be appropriate with a FLUM. So, a FLUM change does not necessarily mean that it will go to the maximum increase. However, that said, I also hear you, Chris, and I think that it is generally true that once a FLUM has passed, it's a strong argument that if the council has decided that that the density allowed, the uses allowed are higher, should be higher for the site than they are currently, that the zoning commission takes note of that, and that they're, in the absence of a good argument for an alternative zone, is very likely to say, well, the council has determined that is an appropriate density, and we're unless we can see some other reason for why not to, that could be grounded, let's say, in the comprehensive plan or in something to do with the zoning, then the commission is likely to go ahead and adopt it. And I think that's the way to respond at that time is to give the commission a different set of goals to bring up if there were, for example, the issues of racial equity that are considerations, or other parts of the comprehensive plan that would be that would suggest that the zone proposed is not appropriate for this particular property.
Because we're over time, I think what I would like to suggest is that we have a follow-up with those interested specifically about how to deal with the FLUM changes, because a lot of communities are impacted by that, right? And they do need to fully engage in the text amendment and map amendment hearings in order to protect that will be the last chance to protect their interests on those lands. And we dealt with that in Berry Farm, and it was very frustrating and unfortunate. We did not have a good outcome. So yes, I see your heads nodding. So I assume that there is some willingness to, dig into that a little bit more, because we have some other stuff we want to talk about today. I think we're going to have to leave it at that, but Alex and Max have agreed to be collaborative and work with us on an ongoing basis. I think, obviously there's a difference in how we've been approaching these issues. There are attorneys who have been within the system advising the zoning commission and are now, in a public interest position. And we've been on the outside, not, I'll speak for myself, not fully understanding these processes and trying our best to engage in them. So I think there's, you know, over time, I think we're going to find that we can support each other. I think we need to let Alex and Max know the things that the public interest, right, is really concerned about, the things that you all need more information and more support around. And then also, you know, we will lean on them to really become more, you know, have more understanding of what the processes currently are. But with that, I want to thank them both for being here, and thank everybody for your great questions. And again, this will be an ongoing interaction. So thanks, Alex and Max. Appreciate your time.
And thank you all.
And folks, they did leave their contact information, and of course, we can send that out later as well. So just you know, feel free to reach out to them individually about specific things in your communities if you want. You know, I think it is kind of hard to cover the whole breadth of the topic and get into the details of each type of decision. So I think to the extent you have a specific issue, specific parcels, whatever specific case, it's a great opportunity to get them to help walk you through, you know, how you can best advocate for your concerns. So we have two more things we want to really talk about today. We're going to have an update on what's going on with Greenleaf and get some action steps for us to support the residents there. And then we're going to talk about the budget and some actions there. So I'm going to invite Chris Williams, and he can let me know who else to spotlight.
We have Miss Linda Brown and Miss Patricia Bishop, who are also on the line. I have just a brief set of slides here I'd like to share, if that's okay, Parissa, to give folks an idea of where we are, where we've been, and where we're going. So just give me a moment here to share my screen. And again, I'll try to be brief because we, of course, want to also hear from the resident leadership. I am the founding editor for Southwest Voice, and I encourage folks who really want more of your questions answered and more background about Greenleaf redevelopment to go to southwestvoicedc.com. We've consistently covered this since our founding in 2019. Our most recent issue really crystallizes many of the issues that I'll be speaking about today. There are ethical, legal, displacement, you name it. We've got it with the Greenleaf redevelopment. And last year, I will say, we printed a story from a whistleblower who is or was working at the DC Housing Authority. The latest issue covers the news that residents in Greenleaf received that Build First was being taken off the table. This is coming directly from the director of the Housing Authority, Brenda Donald. They had circulated materials to residents that more or less intimated that we're not going to do Build First. Instead, we're going to give you new appliances. Right? Of course, that's not apples and oranges, right? Or it's really apples and oranges. And we also published public statements from the presidents from Greenleaf Properties. So if you're not aware, Greenleaf is in Southwest and consists of 3 different buildings: a senior building, mid-rise building, and then what we call the Greenleaf Gardens, which are low density row homes. So I, again, encourage you all to read their statement. Ms. Bishop is on the line, and as well a resident leader from Greenleaf Senior. Following the publication of our story and the really betrayal of the pledge for Build First, there was citywide condemnation. We'd like to thank many of you who attended the DCHA Board of Commissioners meeting, wrote in, to encourage them to not pass the resolution. They ended up passing the resolution on Greenleaf to proceed with the master development agreement, but they also amended that resolution to have a commitment to build first, so that we don't see, as we most often see in public housing redevelopment, wholesale displacement. So we don't want that. And that has been a longstanding principle of Greenleaf redevelopment. Then we had the director of DCHA to issue a letter to Greenleaf residents, part of which I have there on the screen, reiterating that we're going to proceed with build first, no displacement. Bear in mind, half of Greenleaf Senior has been emptied. It was emptied last year in a matter of 2 months. And there are many more empty units within the entire property. So this notion of displacement is really questionable. And of course, we know that the Housing Authority, as well as HUD, the U.S. Department of Housing and Urban Development, their mission is really to serve low and moderate income families. And we do not see any goal within the Greenleaf plan to expand the number of affordable housing units. This is a problem, particularly because Southwest is so resource rich and really could be, really is a protective factor for those experiencing poverty. The engagement around Greenleaf has gone on for more than 10 years. Ms. Brown and Ms. Bishop will speak to their involvement with the project. But the dynamics with the Housing Authority are really problematic, particularly their non-compliance with federal law. DCHA is a moving to work public housing agency. As a part of that, they do get flexibility in redevelopment and in spending, but they also have tenants that they have to follow as a part of being a part of that. And so one is substantially the same requirement, which says that you serve the same number of residents that you would serve otherwise as a public housing agency. And the Housing Authority has not been compliant with that law for several years, has been under a corrective plan for several years. When I began inquiring about this several weeks ago, many on DC Council were not aware of this. And Director Donald issued a clarification on a huge email that I had initiated to all the City Council members. And the Greenleaf redevelopment poses the real potential threat of making them indefinitely non-compliant with substantially the same requirement. We also suspect that DCHA is not compliant with the family housing requirement. Again, this is one of the core requirements of a moving to work agency. This essentially says you have to provide the same number of family units that you had before. So it's really questionable how the Department of Housing and Urban Development could say that they're not non-compliant with substantially the same, but compliant with the family housing requirement. Those two things do not go together. I think the big picture here is to really understand the experiences of public housing residents through the prism of racial violence. And by this, you may be thinking physical violence, but violence in the literature has really been broadly defined. And so when we think of displacement, when we think of poor treatment, when we think threats of retaliation, lack of transparency, misinformation, lack of effective engagement, i.e. cutting residents out of the picture, these are all forms of racial violence that impact both mental and physical health. There's also been a lack of honesty by elected officials. Residents for a long time were reassured that build first sites like the fire station on M Street were viable options. And I wrote an article several years ago following my article in Hill Rag in June 2018 that called into question this. I had private conversations with the housing authority executives, and they said, even if the city offered the fire station, fire truck repair station, we would not accept it. The land is too contaminated. It would be too expensive to rehabilitate. So I encourage you to read our stories in Southwest Voice. Again, I mentioned the whistleblower claims. It's also important to understand that we are at a point of major deviation from the request for proposals. Until recently, well, first, we're still without a build first site. They're considering having it within the Greenleaf footprint, but we still lack details. And build first was a major component of the request for proposals. So the fact that we could have secured a final co-development team and approved their application without knowing that is really a source of major legal concern. There's also an affordable housing land covenant at Greenleaf. So this is different from the Declaration of Trust, and it is also unique among public housing properties in Washington, D.C. You may be aware that HUD has initiated a very vigorous investigation of the Housing Authority. In fact, our last issue of Southwest Voice was released the first day of their on-site investigation, which we thought was very interesting. So the next steps that we're looking at is resident leadership involvement in defining community benefits. They have retained legal representation. There's ongoing monitoring and engagement, and we encourage you to listen in to their radio show appearance on WPFW, Taking Action. And I believe that's coming up within the next week. I wanted to open it up for Ms. Bishop and Ms. Brown. Please, please, please let the folks know what your thoughts are and what you're experiencing.
Good afternoon, everyone. Can y'all hear me? See me? Okay. I've been in this fight from the beginning. And just to speak on the bill first, and where we asked for it in this particular way, so none of the tenants would be displaced and located outside of a 6 to 10 block radius. Somehow, some way, Director Donalds is not aware that this is what we was asking for and how we was asking for it. To say that they're going to use 1200 Greenleaf Senior Building as the relocation spot, that's not what I was speaking of to them. So that's what I mean about the misunderstanding that they continue to do things their way. That's not what we asked for, and we're going to do all we can to put that back on the table the way we asked for it. Plus other additional things. I am now president of Greenleaf Mid-Rise. And to have been on these meetings with the developers, with housing, and asking for them to put things in proper English that everybody can understand, so that I won't have to go through the extra stress of breaking things down to the tenants so that they can understand. I got the 100% support of my tenants here. And I'm going all the way. I'm going all the way. I have let them know that way of them doing business, the same old, as I placed in my article, it's not going to happen with Greenleaf. For them to pass that resolution, that was not the type of resolution that we as Greenleaf leaders was asking for in the beginning. I'm not playing the switcheroo game, the same old, and displacing, in which they have already displaced without anything being in writing. I asked for several things to be in writing. What I mean by they already displaced, they took tenants out of 1200, the senior building, and placed them down into Arbor Capers. They sent them the information through mail, and they responded. Them not realizing that would keep them from being displaced and relocating back to Greenleaf with the right to return. Donalds, Tyrone Gerd, everyone, they knew exactly what they was trying to do. And I am not going to sit back and allow them to keep doing that. Thank you.
Thank you so much, Ms. Bishop. And I'm so grateful that I can consider you a dear friend. And again, we work together, and we struggle hard, unfortunately, because of the virulence of structural racism in this city and in this country. What can folks do to support you and to support the Greenleaf leadership? And then we'll turn to Ms. Brown.
Okay, what we really need now is funds. We need funds. We need printers, like flyers and picket signs. We're going all the way. We're going 100 yard signs to let housing know they're not going to do this to anymore to my tenants or any tenants in Greenleaf. So we need funds to be able to do that, because I don't have the initial amount of funds to hire an attorney to, if we have to go all the way to court, or the funds to make yard signs, protest signs, which we have done in the past, and it's very expensive. People, have donated a lot to help us, but even that is not enough. Listen to us. Come to the Board of Commissioners meetings. Listen to our statements at the public, at Commissioner Board, and see how our words get twisted in the understanding of what we are fighting for. We wanted to go with the racial equality to take away the amount of units and the amount of people to return, and not build even more for the 30% MMI, and get rid of all this market rating that y'all have been doing, and starting off building senior buildings first, and still haven't built the properties from other housing properties that they have tore down, and they're still not in. It is just so hard to keep understanding of why housing has this agenda to do this and continue to do this, without me saying that they are trying their hardest to move us out of the nation capital. I am a firstborn of Washingtonian from my mothers of 12 children. I have seen this go on for so many years of my life. I am not a young chick. I am 62 years of age. And for me to continue to sit back is doing me harm. More harm than me being here frontline for the fight of Greenleaf and other low-income people that needs the proper sustainable housing first. That's HUD's problem, and that's my way of looking at how they're doing. And I just want to reiterate, I see Linda's message. Her mic is not working. She's having problems. So if she still can't join in, I will continue to talk and take questions.
Thank you so much, Ms. Bishop. Ms. Brown, can you test? Let's see if we can do a test. She said she was working on the settings on her phone. Now, if you are dialing in, Ms. Brown, to unmute yourself, it's *6. Maybe we can try *6. Okay. Thank you so much, Ms. Bishop. If we get Ms. Brown on the phone, then we'll of course let her contribute to the conversation as well. But I had a question around the implications of all this work. You have been, even before your presidency, you have been such a strong and visible advocate for your community and other communities. You have worked alongside environmental justice work in Southwest as well. And I wanted to ask you about how this how this affects your health. And I hope you don't mind me sharing, since it has been published in the Washington Post, that you've had 2 heart attacks. And what I need for folks to understand is that we put our vulnerable communities in a position of having to take on more and having to go to the zoning commission repeatedly, having to go to the housing authority repeatedly. And we say, well, that's what's needed to be a part of the process. But that should not be what's needed to be a part of the process. Folks should listen to residents. And I'm an educator in public health at the University of Maryland. And what we should also appreciate is the adverse impact that all of this has on emotional well-being and physical health. And how can we be better allies to our communities is sort of one of the challenges that I want to put forth to folks. But I want to give Ms. Bishop an opportunity to expound on that.
Yes, the 2 heart attacks did occur living here at 203. I was in perfectly good health before I moved here. No heart problems, no pressure problems. But as the years went on, overwhelmed of the stress of the housing, the redevelopment, starting off with Tyrone Garrett, different things at those meetings that I had to address and concerns for the tenants has led me into such a high level of stress personally, because I take my life and other people's life personally into my heart and into my mind. That's one of the reasons why I speak up so much for the tenants, because I don't want them to have to go through what I went through. Even during this pandemic was hard. Living in these conditions is harder. But for them to want to pass the redevelopment negotiations and settings the way they want to do, it's hard for me to keep accepting it. I don't want to have another heart attack. I don't want to go on a second blood pressure pill. But housing have to realize the mental and the physical stress that they are putting on us because of what they're doing wrong, they must abide by us. First, not money from a developer of selling off land, and being that I was so involved with the people at Upper Capers before they tore that down with the seniors, and to see what happened and they went through that. What are our seniors going to go through? I am a senior under so many levels. Plus, I'm disabled. And still, if they realize the rights and the voices of me being just a human being, plus a senior and a disabled, and put us first, that we are fighting for every age, from the newborn to the newborn to become. Correct all your errors that you have allowed us to live in the last 13, 14 years throughout all the years to come. With any other property that you want to go through this with, respect our wishes, because we paid our rent. You got the federal government's money. In return, you're supposed to abide and respect our wishes before you say a dollar amount. Then we'll be in a little better health and more smiles on our face throughout the rest of our lives.
Thank you so much, Ms. Bishop. And I understand that Commissioner Ann Hoffman from the DCHA Board of Commissioners would like to speak. I should add that Commissioner Hoffman has been a major advocate for Greenleaf residents, and I'm very glad that she's been able to join us today.
Yeah, I am too. I've been distressed about Greenleaf for as long as I've known that it was on the chopping block, which is all I can describe it as. And I like to think I had a little bit to do with some of the people who turned out at the last commissioners meeting. I called everybody I knew who could get there, and some of them got there. So the commission has already passed a resolution describing the whole redevelopment plan, except there are no dollars in it, and there are hardly any specifics in it. The bottom line is the last resident will not be moved into a new place until 2035. And that's assuming nothing else goes bad. And so far, there were 3 developers initially. One of them dropped out last month. They say that's no problem. I say that's a problem. But the commission has voted, with only the usual 2 of us voting no, to adopt the plan. And in a couple, either next month or the month after, the commission will vote with 2 votes in dissent to approve the master development agreement. What the Director Donald has convinced enough members of the commission is that Build First is moving people into the vacant units in the senior building, and nobody has to leave the property. Each move will be into the apartments that get vacated on the property. So that is her position now. That is the new definition of Build First. And I don't think we're going to shake her from that. And I don't think we're going to shake the rest of the commission from going on with whatever she says and whatever the mayor says. So I think you almost have to begin to get disruptive. And I didn't say that, but
I will get disruptive, Ms. Hoffman. I am that one that gets in that good trouble, 100% of good trouble. When I say disrupted, look at me, Ms. Hoffman. I am that disrupted, good trouble type of person. Brenda Donalds will not defeat me in any way, because I am not going along with her plans of the same old, and taking anything from us.
she thinks you are. She thinks that the resident leadership has bought into Build First and never leaving the property is just fine. And so, I mean, I hope that residents will file complaints regularly about the conditions you all are living in. I hope you will, maybe if conditions don't get better, you try and go to landlord court and pay your rent into escrow. But yes, you need a lot of attention. And yes, as far as Donald is concerned, she's building first and nobody's being displaced.
Thank you. Thank you so much, Commissioner Hoffman. Thank you so much to the Greenleaf Mid-Rise President, Patricia Bishop. And I just want to briefly connect our discussion to the previous discussion. So there were upfront changes in land use for Greenleaf, and that is removing a sort of major barrier for residents to achieve a project that reflects their needs. And so rather, I think I might have confused myself, rather it creates a barrier because it allows for the development to move forward because of more easily because of the change in land use. The law does require that Greenleaf go through a PUD, but there are potential ways of getting around that. And so we are really looking at one major systems problem with respect to the redevelopment. So thank you both again. And I want to turn it back over to Marissa. Thank you.
Good to see you, Ms. Bishop.
Thank you, Ms. Bishop, for all of your leadership. Amazing. And we're here, you know, anything as you all do your next steps and plan, this group, the DC Grassroots Planning Coalition, and of course Empower DC are ready to support. So we stand ready for direction. I know you've been talking to Daniel and we're coming up with some plans. Some stuff is about to happen on the property, some outreach and stuff like that. So that's great. We're excited to help.
Thank you.
And for the radio show that you, Miss Bishop, and others will be on this Tuesday, 1 o'clock, and that's on WPFW 89.3 FM or online, WPFWFM.org, and it will also be posted after the show if you miss it. Okay, so we're in our last section. We're going to talk a little bit about some budget recommendations and have a discussion. You all know that the city's in the midst of the budget process. The mayor just released her budget the other day, and the council is now having the budget oversight hearings for all the different agencies this coming week and the week after that. I think the total budget now is about $19 billion, if I'm not mistaken, maybe 19 and a half, I saw. So I'm going to share my screen. I just have a couple of slides about what we might do. Let's see. Now I've lost you all. Okay, you guys can see the screen, I think. Can you see it? I'm in
Yes.
I'm in like, whenever I'm using this one computer, I can't see you anymore, but anyway, we'll go with this for a minute. So brief update on last meeting, we talked about pushing for implementation of the racial equity policy and the comp plan. Some of us did give testimony at the oversight hearing. It was very frustrating to hear the agencies claim that they had implemented this policy when we've been following it, and they really have not. We did an action alert. We generated 146 emails to the council about this, and I want to thank all of you who participated, and those emails will also be included in the record of that hearing, basically calling for a halt in the zoning approvals until this is meaningfully implemented. We talked a little bit at the last meeting. We are going to be continuing conversations with the Attorney General's office that we just talked with about how do we push this forward through development of a text amendment that would really specify the racial equity requirement. But this has coming towards the budget. I mean, I think we really should think about some ways to address the systemic problems that we're having with the agencies. And one of the issues is that development review is within the Office of Planning, which is highly politicized, and really that type of function should be within an independent agency. So one possible recommendation is to move the development review out of Office of Planning into the Attorney General's new land use division. But with the racial equity analysis that's required by the comp plan to be conducted by the DC Council Office on Racial Equity, not either Office of Planning or OAG. And recently we met with Montgomery County, the folks there, they have an independent Office of Legislative Oversight, which is the office responsible for conducting zoning review and doing the racial equity analysis. The text amendments in that case cannot be introduced by developers. They can only be introduced by a council member. But I think the key thing here is, again, like they recognize that the zoning review is political and it has to be done by an independent entity. So they do that in Montgomery County. I wanted to just, Chris had pulled this out, Chris Otten had pulled this out of the Politics Hour story and a show a while back featuring Carl Racine. And I think he was talking about the development of this land use division and how under the last 20 years, the zoning commission has really played a key role in the displacement of Black DC residents in particular. And of course, that's under the leadership of Anthony Hood. And so to me, this sets the stage for this whole discussion that, you know, maybe OAG's office could be a place to take on some of that development review. There's some hearings coming up. We might want to testify at the Office of Planning Budget Oversight hearing, which is this coming Thursday. And you do need to sign up by Tuesday if you're interested. And at this hearing, we could raise these types of issues: removing development review from Office of Planning, moving it to the Office of Attorney General Land Use Division with the racial equity analysis to be conducted by CORE. But also, I think enhancing Office of Planning's ability to actually do the racial equity engagement in a meaningful way. They don't have racial equity staff. I was looking at their staffing. There's no division or, you know, any like specific staff that appear to have that as their expertise. As well, I'm personally really interested in trying to get funding for the implementation of the anti-displacement strategy that we pushed for in the comprehensive plan. And we also want to do an action around pushing for new leadership at the Zoning Commission. There is going to be a confirmation hearing to reappoint Anthony Hood. It's not on the council calendar yet, but we think that not only should Anthony Hood not be reconfirmed, but we really need new leadership at the Zoning Commission throughout. The body is not representative. There's no women. There's no people who live east of the river. There's no people with equitable development or you know, racial equity background. And so we think this is a good opportunity to push, and you know, along the lines of what Carl Racine was saying in that interview, we need to make changes at the Zoning Commission. So we do plan to have an action alert coming out that will be timed with that confirmation hearing when that gets on the calendar. So some possible budget asks: moving the development review to OAG, adding the racial equity capacity to Office of Planning and funding the anti-displacement strategy, adding capacity to the Council Office on Racial Equity for both the racial equity review of zoning as well as planning, and for community-led initiatives that I know CORE is interested in doing. We also are interested in funding the master facility planning and moving the whole discussion of whether land is surplus out of the deputy mayor for planning and economic development, moving it to the Department of General Services that is actually responsible for managing the city's public facilities, not developing them, which is what DEMPED does. And in the Environmental Justice Coalition, we're also pushing to have a new interagency council that would create a strategic plan for advancing environmental justice in the city. That would include identifying policies that need to be strengthened. And so there are a number of budget hearings coming up. I'll put that back on the screen here in a minute, but I wonder first from the group, if I can get back to you all, because I still can't see you. I don't know what I can do here. My computer is really not helping me out. Ugh. I don't know. All right, can you guys see me? Maybe if I close everything
Not
else.
us.
Yeah, we can see you.
Okay, now I can see you. Okay, I had to like close every single other tab. My laptop is just crazy. So I wanted to throw it open now, like any reactions to any of those ideas or other budget suggestions. And I do know that Margaret has a budget ask from the Ward 3 Housing Justice. So I'm gonna call on her first, and then I see Anne's hand. If anybody else wants to raise their hand or put something in the chat, please do.
Thanks, Parisa. Hi, I'm Margaret Dwyer of Ward 3 Housing Justice. I think those suggestions that you've made really attack some systemic problems that need to be addressed, and I'm really excited about them. Ward 3 Housing Justice is a grassroots advocacy group that is affiliated with Empower DC and Grassroots Planning Coalition. In fact, we organized ourselves one Saturday afternoon in the chat at a Grassroots Planning Coalition meeting and haven't looked back. We've been we're organizing for affordable housing and economic opportunity in Ward 3, especially for Black and Brown residents who may have experienced or be in danger of experiencing displacement. We've launched a community development corporation, a nonprofit. It's called Northwest Opportunity Partners Community Development Corporation. And they recently were meeting with some of our representatives as well, with Mary Chase staff, to explore sites that would lend themselves to redevelopment for affordable housing. And they encouraged us to look at the Days Inn on Connecticut Avenue, which is for sale, and which is a site where significant affordable housing could be built. You know, a lot of work goes into looking at public land for affordable housing, but in Ward 3, there's hardly any public land available. And so what we've been doing is trying to convince the city to buy land, to make it public land. We started out at the Wardman. We haven't given up on that. We're continuing to push on the Wardman, but the Wardman is really expensive. The Days Inn is much more reasonably priced, we believe. And one of the things that we're still putting together a package and don't have a really specific picture of it yet. We're thinking somewhere in the neighborhood of $15 to $20 million to buy the property, but we're not sure about that. But in the next few weeks, we hope to, and actually in less than that, in the next week or two, we hope to put together a clear figure for it and to have our architectural advisor look at it and see what kind of a proposal we would be building there. It might be something like what we've proposed at the Wardman now, which is that the developer transfer one of the buildings to the Douglas Community Land Trust, and then work with the CDC and the Land Trust to put together a public-private partnership to redevelop the property for truly affordable housing, deeply affordable and moderately affordable in Ward 3. These parcels offer a lot of potential for beautiful communities for folks to live in. And we will be back with more details, but we'd like you to consider this is one of the budget asks that this organization would endorse. Thank you very much.
Yeah, I think it's a great idea, and we should figure out which hearings. I think that there's a hearing on DHCD coming up that might be the right place. They may administer the acquisition fund or the DOPA program, which I think has not been implemented. But so I think that's a great idea. I saw Ann Hoffman had her hand, and then Zachary Curtis, and then Chris Williams. And I know we're at time, so we're going to try to just maybe do 10 minutes and close out. Ann? You're on mute, Ann.
Oh, sorry about that. I hope you don't wait for Hood's confirmation hearing to start the process of coming up with either a slate or at least a list of characteristics and start getting support around it, because it's not impossible, but it's hard to knock somebody down once they're at the nomination hearing phase. And I think it's just so important that there be somebody who lives east of the river, that there be women, that there be people who care about people on the zoning commission, that I hope that gets started right away.
Yeah, that's a great point. But we actually had heard that hearing was going to be this week. So, but yes, it's not on the calendar yet, but that's a great point. And thank you, Zachary.
Hi, I am fully in support of, and I'm really appreciative that there are more and more groups every time I get on this call of locals organizing. What I will say about racial equity is what I've said before, is that the dynamics that we're noticing now are due to specific and targeted legal and illegal measures, from redlining to racial covenants, to extract and steal wealth from communities, so that you have a situation like what we have now, where you know, the need for affordable housing maps onto the question of whether or not Black people can live in DC. But you can't solve racial equity, and I really want to challenge y'all. A lot of the language around racial equity actually is race neutral and is not actually discussing race, not discussing the dynamics that racialize something like housing. And I will say that that is proven time and time again to be ineffective. I think that there's a way to talk about this, but you have to start by talking about the initial and ongoing wealth theft of exclusionary zoning and legal measures. You can't become, we can't become like an all zoning matters initiative that ends up solving Black displacement as an outcome. I just want to say that, even as I stand still in support of organizing, especially if seeing multilateral and multi-ward and multiracial organizing, I believe everybody, especially white residents who may have be tied to the legacy of exclusion, love to see it, want to see more of it, but we really won't get to our goals by being class-based or race neutral. That's personal.
Exactly. I mean, I think that's a great comment and part of a larger conversation, obviously, that we should have, especially as we try to really define, what are we asking the zoning commission to do? What are we saying that the Office of Planning should be doing? I mean, there is some guideline about that is supposed to be looking at history. It's supposed to be looking at current. It's supposed to be looking at future impact. But yes, like I said, it's a much bigger conversation. So we'll have to come back to that. Any last comments on these budget ideas or other budget stuff that anybody in the group is proposing related to equitable development? Okay, so what I'm going to do, I'm going to send you guys a follow-up email. There's a number of hearings coming up. I'm like hesitating to share my screen again because my computer made it impossible for me to see you all. But there's a number of hearings that we might, want to participate in, which Office of Planning, the OAG, the DHC, the Department of Housing and Community Development, the Housing Authority, etc. Margaret, you wanted to make another comment?
I'm so sorry. I just want to point out that there are a number of requests for the information about how to contribute to the fund for Greenleaf residents.
Yeah, I saw that. I'll follow up with Chris and with Ms. Bishop to figure out how to create a mechanism for them. And if Howard DC can help, we're happy to do that.
Thank you.
What I will say is that they have incorporated a entity to receive those funds. So it's just really a matter of getting it so that there is a donation mechanism. And so we look forward to sharing that.
We'll make sure to share that. I think we're going to just go ahead now with like maybe a few more minutes of any announcements that people have. And I think Chris Otten has something to update us on. And then if there's anybody else, please either raise your hand or put something in the chat.
Hi, Parisa, can you hear me?
Yes, we can.
Okay, great meetup today. I think it's imperative to remember we're in an election season, and everybody's various points should be, put before these candidates and see where they're at, whether it's on the racial equity and all the nuances to that we want to highlight, because certainly the incumbents have been around for 20 plus years now, some of them, and have seen this. And if it wasn't for us stepping up, whether it was through appeals or just organizing and advocacy, like these debates and these discussions would not be happening right now. It would be full steam ahead. 60,000 Black folks displaced from DC over the last 20 years. It would have been closer to 100,000 or more if it wasn't for our efforts. And these efforts are critical for our neighbors and friends and every working class person in the city, who seemingly the city just hates. But to the point about the comp plan, we heard earlier OAG representatives talk about how the FLUM future land use map was changed by the mayor and in the last go and back in last summer of 2021. And basically those future land use map changes, as admitted today, will increase development around all those areas of the map that got changed. Now, the question was, well, if we know there's going to be a massive influx of development in the areas where these maps change, why wasn't there impact studies done, such as displacement impacts or property tax increases or anything of real substance that really makes a difference to protect the people who've been here while the city develops? And so they didn't make any attempt. And in fact, we've had an appeal of the changes to the maps. It's not an appeal, it's actually a civil complaint. And when I say we, it's 18 plaintiffs from around the city, almost every ward. I think the only ward not represented is Ward 4. And because there's not a lot of FLUM changes in Ward 4. But bottom line is, just last week, we got an order from the court denying the mayor's motion to dismiss that case. And the judge in that case of this comprehensive plan complaint, not doing impact studies, said he doesn't understand why the studies weren't done. He doesn't understand. And his analogy was that, like with the police jump out squads in the city, when the city was put on notice that they had to do studies about who that was affecting, who the jump out squads are targeting, the city slow played that. And to the point where all of the judgments in court against folks who got harassed and arrested by the jump out squads, whether they were in the wrong or not, got flipped. In other words, they were all released. All those folks who were charged and in prison were released because of the lack of study done by the city with regards to these jump out squads and the racism there. And so his analogy was to that. He said with the comp plan, he said all of these pending land use decisions at the zoning commission and things that are based on this new comp plan can be flipped in the future because of this fundamental lack of interest in studying the impacts and who is directly affected by these changes. And I thought that was really startling to hear that. But the order came out, the mayor has been denied. We get to go ahead and we now get to depose the city planners, the mayor, and we get to ask questions about why these impact studies weren't done and get as much information out of them as possible. I encourage everybody, if you're interested, to and I can put it in the chat, but email me and I'll send it to our attorney and the 18 other plaintiffs. Any information you think the Office of Planning should have relied on in the changes to the comprehensive plan, any information at all that you think, any reports you think the city should have done during this process to ensure that the changes to the comp plan, which affect nearly everybody, but certainly the people around the areas where the map changes happened, very specifically those folks. But you want to send me any information, anything you think we should be asking the city to turn over to us, and I'll put my info in the chat. But it's really huge news, and it really actually bolsters all of the conversations we've had today about how the city has just put the developer's bottom line above people. It should be the other way around, obviously, people over profits, but it's not that way right now. And the comp plan lawsuit will actually bring all that to light. I'm very excited to report that to everybody.
Thanks, Chris. Good work on that. Okay, well, we're over time. So, and I know it's a beautiful day outside. I think a lot of people are out and about today already, but I want to thank you all for spending some time with us. We will send some follow-up quickly because there are, again, those hearings coming up quickly. And yeah, lots of stuff to continue our work on. So feel free to unmute and say goodbye to each other as we say thanks again for being with us.
Goodbye, everyone. Thank you.
Take care,
It is
everybody.
always
great meeting.
terrific.
Great meeting. Thank you, Parisa.
Great. Someone
Incredibly rich. Thank you.
Yes.
And I'm glad you all got something from it.
Yeah, it was great. Thanks.
Thank you, Chris. I don't know if this was anyone